Okay, well, I think we'll start this session now, and it gives me great pleasure to introduce 4 human rights practitioners, barristers, to this plenary. So first of all, our first speaker is going to be Eileen McColgan, KC, who has a distinguished career as an academic and a leading expert in discrimination, equality, and human rights law, and she practices in those areas as well. And she's just published the 3rd edition of her discrimination law text, which is enormous, and this year. And she is certainly a leading advocate in human rights law and discrimination and equality. But also importantly, for our purposes, she is a very dedicated and loyal member of the board of the European Human Rights Law Review. And then secondly, I'd like to introduce Ivan Hare. It gives me great pleasure to welcome back a former colleague of mine here at Cambridge. He was a colleague here for 12 years, a fellow of Trinity College, and in fact, he still teaches for them administrative law. He's been in practice at the bar since 2004 at Blackstone Chambers, and he has also continued to publish and is now the lead editor of DeSmith's Judicial Review. And the 9th edition just came out in this year. And then we have Tatiana Eatwell, and it gives me great pleasure to introduce her back, as she has a Cambridge connection. And in fact, she was awarded a PhD in public international law here at Cambridge in 2020. And like Keelan Gallagher, who I'll introduce in a moment, she is at Doughty Street Chambers and is team leader of Doughty Street International. And then last but not least, Keelan Gallagher, KC, who will join us online. She's in the United States at the moment. And Keelan, I first knew Keelan as a passionate student in my human rights class in Cambridge many years ago. And she was certainly passionate about human rights then. And luckily for the world, she's still passionate about human rights. And she's acted in many leading human rights cases and in many fields, including freedom of expression, open justice, and women's rights and children's rights as well. So thank you. And Eileen is going to lead the way. Thank you.
Thank you. This is sort of law light, I think. We were talking about what we were supposed to talk about, and it's slightly how you came to be a practitioner and a bit about being a practitioner. So what I've put some questions: why, how, what, and then current human rights discrimination controversies. So I ended up as a human rights practitioner in a very odd way, partly because I didn't go to the bar directly. I was an academic for years, first of all, but also because of how I ended up being interested in human rights. So when I was 5, myself and my family moved from Belfast to Derry. That was in 1971. And having come from a middle-class school in Belfast, I found myself in a primary school at the edge of a council estate, Catholic council estate in Derry. And I came home that night saying to my parents, I had long blonde ringlets and this little flowery blue dress, and I came from a very supportive family. Came home saying to my parents, what's internment? Because 3 or 4 children in the class, their fathers were interned so it was extraordinary to be told, oh, that means my dad's in prison. Why is your dad in prison? We don't know. Well, what do you mean you don't know? So that was, I think, looking back, quite a significant starting point for me. So that's not to say at age 7, I decided to become a human rights lawyer. Ended up going and doing a law degree and discovering discrimination law very briefly as an aspect of labour law. And then I went off to Edinburgh to do a master's and discovered feminism, both culturally and as a legal subject. And I was exposed to feminism in law. I was exposed to sort of philosophical feminism, and I was exposed also to an awareness of the impact of discrimination at that stage, unregulated by law, when one woman I met there was in a relationship with another woman who was in the military, and this was something which was actually a criminal offence at the time. So that was a sort of conglomeration of things which stayed with me. And then I became an academic and was interested in discrimination law, spent some time in Canada and discovered the Canadian Charter of Rights, which had just been a little while before that had come into force. And that sparked an interest in human rights, which then produced a book which was very skeptical about human rights, because when I was in Canada, I learned things about the misuse of sexual history evidence in rape trials as a result of human rights arguments, and the threat posed to women by notions of fetal rights. So anyway, all of that sort of came together, and then lo and behold, Human Rights Act and Matrix Chambers opened and wanted academics as barristers. I wasn't a barrister, so I managed to get into a set of chambers without being a barrister, became a barrister. Connor's laughing. He wasn't actually one of the people who interviewed me, but he was already in Matrix at the time. He slipped me in. And then I transferred to the bar, became a barrister without having to go to bar school, which I would thoroughly recommend, and ended up, I thought I'll do a little bit of practice, a little bit of consultancy, and I'll continue to be an academic. But that stage I was a professor of human rights law at King's in London, where I was for over 25 years in total. And then I got bitten by the bar. So my early cases involved Ladele. Some of you may be aware of that. It was a Christian registrar who, in Islington, who sued the council because she was required to participate in same-sex civil partnerships as a registrar of births, marriages and deaths. She ended up taking that claim to Europe. I wasn't involved at that stage, but it was an amazing thing to be involved in when I was, really a baby barrister. Another one was Gurung and the MOD, and that was one of the early cases on discrimination against Nepalese Gurkhas who had been British enough to be interned by the Japanese, but not British enough to be given compensation payments that other internees got. And that was a case which taught me a great deal, because at the time, couldn't litigate it under domestic law for various dull reasons. The Race Relations Act didn't apply. Couldn't litigate it under the Human Rights Act because at the time, the nature of that compensation payment didn't fall within the understanding of Article 1. So we ended up litigating that as a common law wrong, and astonishingly won. I mean, I was the junior on the case, I wasn't leading it, but it was an amazing introduction to the excitement that you can gain in this area of law. So you could be a commercial lawyer and earn a great deal more money. You could go into chancery and make a fortune, or you can do stuff that gets you into human rights arguments, which generally is much more interesting. So in the end, I decided to just throw in academia as a source of a significant paycheck and come to the bar. And I don't know what a normal human rights practitioner is, but I do mainly discrimination. That's a bit of freedom of expression, discrimination. I don't do much international law practice, and a lot of what I do in human rights law is really through discrimination law. So there's the occasional exception to that. One recent one was a case for the Tate. We lost eventually, but at least this was the case where the rich landowners with their glass-fronted houses were complaining about the viewing gallery. And my job was just to make sure that we didn't lose on human rights grounds. So we did lose House for the Tate, and we did lose, but we didn't lose on Article 8 grounds. So I thought that's fair, and I'll take that. One of the areas which features very significantly in my practice at the moment, and I'll just say a few serious words about, is the the tension between gender and sex. And there have been a number of important cases, some of which I've been tangentially involved in. And so you've got Forstater, for example, and that was a case which was brought under the Equality Act and ended up with gender political feminism being recognised as a protected characteristic, or as a protected belief, not a protected characteristic, a protected belief. But what was crucial in that case was the interplay between the Equality Act and the Convention, in particular, freedom of expression and freedom of expression, as well as anti-discrimination. And oftentimes in my practice, human rights arguments get fed through discrimination, or indeed fed through public law. And for me, I don't consider discrimination human rights practice as separate and distinct. I also now, as a practitioner, look back at my book on the perils of human rights and smile, because it was very much an academic's book. And I remember something that Stephen Sedley said about human rights when challenged about the fact that he had been a human rights skeptic and then was an enthusiastic adopter, in a sense, with his practitioner's hat on him. And he said, well, I once heard from an electrician, or human rights are a useful tool in the toolkit. So an electrician doesn't really eschew particular tools because he doesn't approve or she doesn't approve of them. Human rights for a practitioner can be a tool in the toolkit. And just briefly, before I go, I think I kind of came into human rights feeling very much not an activist, but someone who came from an activist sort of position. And as I say, I was interested in human rights primarily because of my feminism and my sense of the injustice perpetrated on minority people in wherever they are. But it's an interesting thing that when you end up doing practice, and in particular when you end up doing practice in an area like the gender, sex area, or practice around where the parameters of anti-Semitism are, which so I smiled at Conor this morning. I thought, well, he's not having to litigate this. you actually, I've discovered that I end up really censoring what I say externally, because law can be a really helpful tool to try and negotiate balances between some of these very difficult rights. And human rights is absolutely perfect for that, because it is almost always about balance. But what you then don't want as a practitioner is to end up excluding yourself from being able to be involved in case law, but also in advisory work, which is hugely important where you've got controversial things going on. You don't want to exclude yourself from being able to be involved in that kind of stuff by virtue of being too much of an activist. So that's something I never thought that I would end up coming to, because when it was just feminism in the sense of, anti-violence against women and pro-choice, I never felt that would would end up being excluded from anything. But I think some of the controversies that we're dealing with now are really, really quite tricky to negotiate one's way through as a lawyer. So I think I'll stop there. I'm sure that's 10 minutes and with very little law. But
Thank you very much. I am going to talk a little bit about law. I'm not going to talk about any of my cases because I don't think it would be fair to inflict that on a paying audience. And because I've lost so many of them, it's a little bit traumatic for me to revisit them. So I'd rather not do that. It's also maybe not very interesting. I mean, my family certainly has no interest at all in any of my cases. There was a moment when I thought my children were starting to get a little bit interested, but was, as you'll hear, immediately shattered. On a long car journey, my eldest daughter, when she was about 6, said, Dad, why don't you tell me about one of your recent cases, a short one? So I thought whatever interest she has, you know, is not really going to endure going through the whole thing. So even though I've only got 10 minutes, I'm not going to talk about any of my cases. My most traumatic childhood experience, I grew up in Lincolnshire in a very stable family too, was when I dropped a sausage roll when I was 5 in the sandpit, thereby rendering it completely inedible and irrecoverable. But so I think that's up there with meeting parents who are returned. I did want to say something though, and this is where the law bit comes in, that does have some legal content, but arises out of writing that I've been doing about the Colston case. You'll remember that case about the statue, and I've got some lovely photos to show you. So when you come to write your assessment at the end of the conference, even if you didn't think much of the content, I should get some credit for the photos, I think. So you'll remember the Colston controversy. So it was in June 2020 when there was a Black Lives Matter protest in Bristol, not long after the George Floyd matter had hit the public attention, as it were. Something like 10,000 people marched very peacefully through the centre of Bristol, most of whom had passed the statue on Colston Avenue of Colston, who, as you know, was very heavily, not only very heavily invested in, but was one of the directors of the Royal Africa Company, which had a monopoly on the slave trade in the 17th and 18th centuries, and a group of people who'd plainly come equipped to do so, as you can see from this. Oh, no, not from that one. Sorry, I've got a different one on my screen. So that's what it did look like. That's the before photo. Oddly, the English Heritage, which had listed it, it's all right. It's not, no, I haven't pressed the button yet. It's okay. There you go. Yeah, it does go. It does work. But sorry, it's just a different one on my screen. So that was the picture into 2021 and did it quite a bit after. English Heritage still had that picture on its website when if you went to visit the listed monuments in Bristol, with a little caveat that's sort of more relevant, you might think, than usual, which said, this may not represent the current state of the monument, which is their standard thing. But what happened then was this. So you can see lots of people went equipped with ropes and things like that. Somebody's got his shopping bag as well, but maybe that's what he had the ropes in. It was pulled down. Then it was sprayed, the hands sprayed red, various other things sprayed on it. And then very slowly, because obviously it's very, very heavy, it's about 3 times life size, it was rolled down Colston Avenue to the harbour. And there it is on some more ropes being lowered into the harbour and then going, gone. A few days later, it's fished out by the council. We'll come on to the relevance of that in a minute. And that's where it wound up, at least for a period, in a museum called the M Shed in Bristol, as part of a display about Bristol, the history of slavery in Bristol, which is obviously a crucial port in the transatlantic slave trade, and as part of an exhibition about the strength of feeling in relation to the Black Lives Matter movement. And that was the point, really, and it's being so committed to recycling. I've written 3 papers about this matter. So it's getting a bit difficult to think of a title, but the first one was Statues, Statute and Freedom of Expression. I like that one. Yeah. It's about the Criminal Damage Act. I was quite pleased with that one. And the point of that one was before the trial, I thought, what arguments are likely to be deployed to defend the 4? So you probably know, no one was arrested on the occasion. There's a very heavy police presence. No one was arrested. The police then put out a request and a load of photographs, so probably some of these, to say, if you recognize any of these people, please get in touch with us. 10 people were arrested, 6 of whom accepted a conditional discharge, which meant they had to do various forms of community work and so on, pay a fine. 4 of whom went for trial, elected for trial in the Crown Court, so before a jury, and they were all acquitted. But before their trial, which was at the beginning of 2022, I think, I wrote this article in Public Law, trying to anticipate the arguments they might run. And one argument, which seemed to me to be unanswerable, was that they've been charged with the wrong offence, because criminal damage, many of you probably know, is a bit of a weird offence in the sense that there's no definition in the Act, or really at common law properly, as to what criminal damage is, or what constitutes criminal damage. In most cases, it's pretty obvious. But in other cases, it isn't. And it depends, the actus reus of the offence, so nothing to do with the mental element. The actus reus of the offence depends on the response of the owner. That's very unusual, isn't it, in criminal law, if you think about it. It doesn't matter if you're charged with theft, if the original owner of the property thinks, well, maybe you need it more than I do afterwards, you've still committed theft. Or in an offence against the person, it doesn't matter if the victim says, well, I deserved a pasting. Actually, I was being really annoying. It's still, the offence has still been committed. So it's not normally relevant. It's a bit of a weird thing about the law of criminal damage, but you can see how it might work. So in a case like this, if the council had decided to remove all that graffiti, there's quite a lot of physical damage to the bronze as well. You can see he was leaning on a sort of staff when he was on his plinth. You may remember when I showed you the first photo. So that snapped off. Part of the tails of his coat there snapped off as he was being rolled along. If they cleaned the graffiti off and restored him, put him back on the plinth maybe, that would have been criminal damage, because the owner, who was treated as the council for these purposes, had to go to the expense of restoring the property to its original state. But that also means, if that's the, where you quantify whether or not there's been damage, whether you tell whether or not there's been damage, and then whether you quantify it, the quantification is relevant for mode of trial. If it's over $5,000, then you go to the Crown, you automatically generally go to the Crown Court. If it's below that, you normally go to the magistrates. The converse of that must be true as well, right? So if the council has decided the conduct of the defendants hasn't actually damaged it, but it's been part of repurposing what this piece of property is for, it's not now a representation of Colston and his charitable contributions through almshouses and schools and public housing and things like that, which he did give a lot of his ill-gotten gains to, or in his will anyway, that's where they went. It's now the purpose of the Colston statue. There's a bit of a clue in the fact that it's displayed on its side, isn't there, rather than being upright. The purpose of the Colston statue is now something completely different. And one of the council's conservation officers said this: our main concern is making sure that we can conserve the paint, the graffiti that's on him now. It has become part of the story of the object, of the statue. So our job is to try and retain that as much as possible. So there's a real contrast there with some of the other examples of criminal damage of works of art. I mean, I'll use that term loosely. Public monuments might be a better one in relation to the Colston statue, which no one would say is a great work of art. But this is the Rokeby Venus in the National Gallery. Remember, Mary Richardson attacked that with a hatchet. It had to be restored. That's what it looks like now. But the fact that it was restored and the National Gallery was put to the expense of doing so means that was a case of criminal damage, although of course it was under the Malicious Damage Act at the time when she was prosecuted. But that argument simply can't apply. So the very simple answer should have been, when the prosecution closed its case in the Colston prosecution, the defense should just have said, the prosecution hasn't produced evidence that the actus reus of the offence has been carried out. Now, the defense did run that argument, but of course they ran it along with lots of others, and we'll never know which one the jury actually bought. But the wider implications, I think, of the Colston case emerged from what happened after the acquittal of the 4 defendants. So what then happened was there was an Attorney General's reference. As you know, that can be often on sentencing, where sentence is considered to be insufficient to protect the public. But you can also have an Attorney General's reference on a contested point of law, where the attorney invites the Court of Appeal to clarify the meaning of a particular area of law. The area that the attorney asked the Court of Appeal to clarify in the Attorney General's reference, it was number 1 of 2022, was not about the point I've raised on the Criminal Damage Act, but about the scope of the defence they relied on based on Article 10 and Article 11 of the European Convention on Human Rights, and the extent to which a trial judge or judge and jury has to address the question, has the prosecution demonstrated beyond a reasonable doubt that convicting the defendants in this case would be a proportionate response to their conduct in light of the exercise of their, in other words, wouldn't be a violation of their convention rights. Now, as you may know, in the Ziegler case, the case about the blocking the road outside the arms fair, and that eventually got to the Supreme Court. The Supreme Court said you might think quite reasonably that you do need to address that as part of a criminal trial, especially if the offence is one where there's a provision which says you can have a lawful excuse in certain circumstances, like the offence they were charged with under the Highways Act. But since that case, as you probably know, in a whole series of cases, particularly in the Court of Appeal, particularly by our current, but only for 2 more days, Lord Chief Justice, who retires the day after tomorrow, as you probably know, in which he appears to have been sort of leading the charge to say, well, Ziegler might have said that, but it can't really have meant it because we don't want first instance judges, magistrates, say, or district court judges, or even juries having to grapple with the horrors of the convention compatibility of a conviction. And have said basically that, no, you don't need to worry about that in most cases. And the first sort of step on that line was to say, well, Ziegler's, as I mentioned, really about only those cases where there's a lawful excuse defence. It now looks as if the most recent Supreme Court authority says you don't even need to worry about it necessarily then. Mostly, you can assume that the balance between convention rights is appropriately struck by the legislation itself. So you don't need to ask yourself the question. And that's pretty much the answer that the Court of Appeal came up with in the Colston reference. Yeah? They basically said this was obviously a serious case of criminal damage, and in any case where there's serious damage to property, it either falls outside your Article 10, Article 11 rights, so then obviously you don't need to worry about balancing. And even if it doesn't, even if it does fall within your convention rights, then an interference is relatively easy to justify as proportionate because there's some serious damage to property that's been done. So it shows a couple of things, doesn't it? And this is one of my little sort of bugbears about, and it is a practical matter about human rights practice, is the difficulties you get into when you isolate one issue like that to send up to the Court of Appeal to address. Because of course, if my argument's right, and if the jury actually had acquitted them on the basis that they couldn't be convicted under the Criminal Damage Act, then this rationale for the Court of Appeal's decision just falls away because there was no criminal damage at all, let alone serious criminal damage in the Colston case. So you would have to grapple with it because they did accept if there was very limited, or for example, if you chalked something on the wall and the rain would wash it off, you know, in due course, then the Court of Appeal was prepared to accept that prosecuting for criminal damage, it can be criminal damage because, you know, if the owner's gone along and gone to the trouble of washing it off, that would be enough for criminal damage. But the Court of Appeal said, well, that might be a case where that would be disproportionate to prosecute in those circumstances. So in a case where there's no damage, by definition, if I'm right, then that obviously couldn't occur in this case. So that's really what I wanted to say to you, and it's really a question I wanted to ask you about, because if you talk to some criminal lawyers, they say, of course you don't want juries or district judges or whatever deciding these matters. And I just don't know if that's overstated. It seems to be very much overstated. The Court of Appeal is very, very worried about it. It's not just the Colston case. There's a Jones case, Kekurian case, and then the Northern Ireland abortion case as well, all of which have taken that line. As I say, the Supreme Court now in Lord Reed's judgment in that Northern Ireland abortion case has taken a very firm line on it along the lines of the Court of Appeal. And you wonder what they're so worried about. I mean, as appellate judges, as you know, are mostly worried about having too many cases to decide. So they're often quite keen to say, no, this is a pure question of fact. So you can't appeal it to us because we only deal with issues of law because we're very important. And they can't really say that about this, can they? Because it can't be the proportionality of a prosecution can't be a pure question of fact. Of course, you have to take account of the individual facts and apply it. but it can't be a pure question of fact. So they want to say, no, it's all, the balance is struck by the legislation. Well, yeah, maybe in some cases, but it's clear, isn't it? If you think about the 1971, was Parliament thinking about Article 10 and Article 11 of the Human Rights Act when they determined the definition of what would constitute criminal damage? It's not really plausible, I don't think. So my thought was this. First, so how else might you address it? Because obviously nobody wants the courts to be clogged up with all these appeals if it's pointless. First point surely is charge the right offence. So the Colston defendants were plainly charged with the wrong offence. They should have been charged with a public order offence, a riot or violent disorder, to which they would have had no defence. Wouldn't have mattered then if there had been no criminal damage, if the property itself wasn't damaged. That defence wouldn't have been available. But you would definitely then surely have had to address their Article 10 and Article 11 rights and whether it was proportionate to convict them in those circumstances. If you're worried about district judges deciding it, well, maybe just train them a bit better. It's not hard to train them to spot a really hopeless human rights argument that's being run in front of them, which they can deal with very quickly and dismiss. But what we've wound up with, this is my last point, I'll finish on this. What we've wound up is a case like the DPP versus Cathy Eastburn, decided by the Divisional Court this summer, where Cathy Eastbourne had been protesting in Parliament Square as part of an Extinction Rebellion protest in September 2020, a golden year for public protest, 2020. And there'd been a condition imposed, quite lawfully, by the senior police officer that the protesters that day should be confined to Parliament Square gardens, the bit of grass in the middle surrounded by all the statues, rather than the road. Miss Eastbourne and a couple of other people sat down for a very short period of time on the roads. The road's enormous, about 4 lanes of traffic. There's lots of photographic evidence, and there were the cameras that the police officers had at the time when they went to remove them. They weren't causing any kind of obstruction. They were there, as it turned out, for a matter of a few minutes. And the district judge acquitted on that basis. She said, I've got to consider whether or not the conviction, not just their arrest, whether the conviction is proportionate. In this case, it's not proportionate, because the reason for imposing this, to avoid very serious disruption to the community, simply wasn't implicated by what they were doing. And for heaven's sake, it's quite an important matter they were protesting about. It was the day that the climate emergency bill was being debated in Parliament. That's why they wanted to be there, and that's why they were there in such great numbers. Divisional Court said, for the reasons I was talking about previously, that the Lord Chief Justice has been so keen to emphasise, no, you don't need to address that at all. Once you establish that the condition, when it was imposed, was valid, if there's a breach of it, then you can convict without considering convention rights. And in fact, they returned it to the district court, to the district judge, with a direction to convict. Thank you very much.
So thanks very much, Ivan, for that lively talk. And so now Tatiana Eatwell is going to talk to us.
Hello, everyone. Thank you for staying on to the sort of late hour. I know you've had a really interesting day. Unfortunately, I haven't been able to be at the conference myself, but I saw the programme. It looks amazing. My name's Tatiana Eatwell. I'm a barrister at Doughty Street Chambers in London, and it's a real privilege to be here on this panel with these extraordinary speakers and with Keelan Gallagher-Casey, who's going to be beaming in to us, who's a colleague of mine in Chambers. And it's also a great privilege to be here speaking at this conference that's honouring Jonathan Cooper, who was a colleague and friend in Chambers and who I was working with on one of his two cases, his 2 themes when he died was the 2 Bs, Biafra and Belarus. And Johnny didn't really take on easy cases. He was involved in some extraordinary human rights cases throughout his practice and throughout his life. And the 2 Bs were the last 2 themes. And it's these kinds of hard cases, hard human rights cases that I'm going to speak about today. It's also great to be back in Cambridge. It's been 4 years and I almost lost my way. It's really nice to be here again. So my practice is in international law, in public international law and international human rights law. And quite a large portion of my practice, not all of it, doesn't involve going to court at all. And that's international human rights law, where the individuals or groups of persons that I represent are often in states or jurisdictions that may have, but may not have ratified the International Convention on Civil and Political Rights, for example, may not have ratified any conventions at all, and ordinarily have not recognized the competence of an international or regional tribunal to accept individual complaints. So in terms of talking about the themes of this conference of prospects, possibilities, fears, and limitations, I'm going to first go to limitations. What are the limitations in these cases? Well, they are there. The fabric, the framework of international human rights law is limited by the fact that states, not all states, have accepted the competence of an adjudicatory mechanism to consider cases. And that has two consequences. Well, it probably has a lot more, but I've identified two for today's. And that's in the development of international law in these regions. You see that speaking about development of human rights law, we often focus on the European Court of Human Rights, which has been incredibly important in the development of human rights law, particularly for Council of Europe states, but is looked to by other states around the world, and also the Inter-American Court of Human Rights, and then the African Court and the commissions. But what that means is that regionally, in terms of the body of human rights law and the substance of it and the principles, it's very much focused on where these regional tribunals are. When you look to the UN and the overarching mechanism, you will have the committees to the treaties, like the Human Rights Committee, publishing their general comments. But if you've read them in your studies, they're quite sparing on the detail and the analysis. And so in terms of development of international human rights law, globally, universally, it is somewhat potted. And we do rely on academics in order to develop those ideas. And academia is incredibly important there. So thank you. But also we do rely on UN mechanisms and states really pulling together and supporting inquiries into particular situations, which aren't so much development of law, but certainly provide some form of accountability or some form of factual analysis when applied to international human rights principles of a particular situation. But again, that is extremely potted. And then the second consequence of that is for individuals. And as a practitioner, I often represent individuals. And for those individuals based in those jurisdictions, their access to remedy, to accountability is hampered, extremely limited, particularly when they are in a non-rule of law compliant justice system. Domestic remedies are not forthcoming, where a state is intent on ignoring its international obligations, whether it has ratified a particular convention or whether they are in customary international law. And these are the kinds of cases that I have worked on. I work on with Keelan currently, many of them, and to which I'm addressing my remarks today. And so to give you a bit of background in terms of the cases that I've done recently, I represented Nazanin Zaghari-Ratcliffe and Richard Ratcliffe, and Nazanin was a British-Iranian national arbitrarily detained in Iran for 6 years in a justice system, facing a justice system where there was no justice. It was wholly arbitrary, show trials. I mean, the lists of violations of her rights was extensive. And other cases involving journalists killed abroad in states like South Sudan, or in Libya during situations of armed conflict. And now, more recently, a case of a British Hong Konger arbitrarily detained in Hong Kong called Jimmy Lai, who's a journalist and owner of one of the largest Chinese language newspapers before it was shut down in 2021. What these cases have in common is that they are jurisdictions that do not recognize or have not recognized the competence of a regional human rights mechanism. So what are the possibilities and prospects for these cases, particularly as a practitioner, not as an academic exercise, looking at how the law might be applied, but how do we really secure remedies for our clients or for victims of grave human rights violations in these circumstances? And what Johnny Cooper understood, and what is understood by many within who do this kind of thing, is that the answer is not always in law. It's not always in the judgments of courts. There are no courts to give that judgment. The answer and the remedy is often political. It is through diplomacy, and it's through states, to put it in sort of water cooler speak, reputation management of states. So why are lawyers involved? Well, the work in this case, in these kinds of cases, requires you to be creative with your law. You're not in courts. And a lot of the advocacy is with governments, with UN experts at the Human Rights Council, and missions there in Geneva or indeed in New York, persuading them of the importance of your particular case and of the issues of which it's emblematic, and rallying states around this cause. And that rallying is done through the language of law. We're having international human rights law principles as their foundation, in order that those states apply pressure on the rights violating states, such that the cost, the political cost of continuing with the course of conduct, whether it be against a group or the particular individual, is so much, and it does not end of, well, it's too much to bear for that state, such that the benefit of maintaining that course of conduct is outweighed by that political cost. So that process, people might say, is not so much lawyering, but it is very much an area of practice of international human rights law that's incredibly important. I'd say, because if one focuses only on lawyering in the courts, then you're missing a vast swathe of the world's population who have no access to remedy. And it's through these soft international human rights law mechanisms that you can really affect change and really make a difference. So the weaknesses in the international human rights law framework may place limitations, but there are prospects and possibilities for creation of change, creating change, and ultimately securing remedy for your client, whether that be release or some form of compensation or apology. So these cases, the road can be a long one. In Nazanin's case, she was detained for 6 years, but there is an end to it in some of these cases. So prospects for the future. What are the prospects for the future of international human rights law in circumstances where the development of jurisprudence is potted and perhaps Eurocentric, although the Inter-American Court of Human Rights has made some really important decisions in terms of women's rights and violence against women in recent years that really have a really important impact on the development of international human rights law generally. Well, it's easy to be cynical and skeptical about it when you're trying to persuade your own government that they ought to be doing more to help their own citizen whose rights are being violated abroad, and you are met with hesitancy. You can feel downbeat. But through this process of continually advocating for rights within this forum, within the UN forums, which states try and maintain, and states like China or Russia really enjoy, because it's all about dialogue and just having a conversation, and nothing's particularly binding. And it's a talking shop for states, but using that talking shop for the benefit of your client and really poking, I was going to say poking the bear, which is Russia, but poking whichever bear it is around the world, and demonstrating that civil society's voices and individuals' voices are as important in the international human rights law frameworks and mechanisms, and being persistent and in maintaining that can really drive a force of change. And also you can see in the development of coalitions of states around particular issues that this kind of what might think of high level advocacy and international human rights law advocacy can impact on what states do in order to affect change themselves. So one of those examples, if we go back to Nazanin's case and arbitrary detention of dual nationals in Iran, is the Ottawa Declaration on, it's very wordy, arbitrary detention of dual nationals for diplomatic leverage, aka state hostage taking. That was signed by a number of states. I think the number is now getting up to 26. It's not that many states. It's an increasing number. Maybe it's getting up to the 50s, of really a declaration of international law principles that already apply. But upon that, and as we all know, that's not binding, but that was a real statement of a way to move forward. And that those coalition of governments are now looking into ways of strengthening not only the international legal framework in terms of providing diplomatic protection and consular assistance to persons who are being taken hostage or are being used for diplomatic leverage by states, but also to inform domestic law and what rights and responsibilities and duties governments might have towards their citizens. So that's a very positive history of the kind of the way in which international human rights law may develop in the future through this kind of advocacy. I don't know how to conclude this, actually, other than to say thank you so much for listening. You are now going to have Keelan Gallagher, who's absolutely brilliant and who I work with all the time, so a real treat. So please don't leave the room if you're thinking it's getting a bit late. And thank you very much, everyone.
So thanks very much, Tatiana. And now we're going to have Keelan Gallagher join us from the United States. So welcome, Keelan.
Thank you so much. I hope you can hear me.
We can hear you. Thank you.
Wonderful. Well, could I start just by thanking the organisers for inviting me to join today? It's particularly special to be joining you, albeit remotely, at West Road, where I lived as a postgraduate student doing the Cambridge LLM 22 years ago, almost quarter of a century. And if that makes me feel old, I can always comfort myself with the thought that both Stephanie and Ivan taught me at that time. So they are definitely older. But it was certainly an inspirational year for me personally and had a profound impact upon me professionally. And rather in line with Aileen being law light, I thought I'd just start with a little about how I've ended up in the position that I'm in. So I started doing my LLM in Cambridge in October 2001. So in the shadow of 9/11, at a time when thousands of bereaved families and tens of thousands of survivors were dealing with the impact of a horrendous terrorist attack. And in the months following, we saw the international human rights system and domestic human rights systems in multiple countries under tremendous pressure, with major human rights and civil liberties incursions in the name of security, including detention without trial, racial profiling, surveillance, and we later learned the horrors of rendition, waterboarding, and torture. And of course, even 22 years on, Guantanamo Bay still has 30 prisoners as of April 2023. Now, by the time I came to Cambridge, and Stephanie referred to me as being passionate, which I think is probably a euphemism for rather a few other things, but I was certain that I wanted to be a barrister. I'd already qualified as a barrister in Ireland at that time, and I knew I wanted to do human rights, civil liberties and public law work. And I'd always been more drawn to the Davids rather than the Goliaths, the little guys standing up to the system. But getting to that point in 2001 had taken some thinking, and as I suspect many human rights lawyers have, some meanderings along the way. So in some ways, it will surprise no one who knew me when I was younger that I now argue for a living. And from the outset in childhood, I definitely had the it's not fair gene. I grew up in Northside Dublin in a working class area in the 1970s and 80s. I went to a huge kind of comp state school, and I grew up in a house jammed full of books and with parents who taught us we could do anything. And although there were many books all over the house, there was one room entirely devoted to them, a book room, extremely unusual, the largest room in the house in a small suburban 4-bedroom house. It was like an untended garden, full to the ceiling of stray leftover books, opening windows onto the world. And I and my sibling were encouraged to think there were no limits to what we could do. So I knew from an early stage that I wanted to do something that makes a difference, cheesy and all as that sounds, but I wasn't quite sure what that something was. At one point I was obsessed with being a writer. I even started doing an English degree before transferring to law. Acting was always on the radar when I was a teenager as well. My parents were concerned about how uncertain the acting profession is. So imagine their joy that I've ended up as a self-employed barrister who performs for a living. But really, many things led me to the year in Cambridge, which was life-changing for me, and then ultimately to the London Bar and to Doughty Street and to an international practice, which results in me sitting in a space in New York with terrible piped music, which I hope you're not hearing. And a book definitely contributed to that. And at a risk of sounding rather stalker-like, a person who was hugely influential on me before I ever met her, and I'm about to meet in a few minutes here in New York, and that's Helena Kennedy, KC. And Eve Was Framed was one of those life-changing books, which I read as an undergraduate student. And it made me think differently about the world and about the law and what the law could and should do. And I pinch myself all the time that she's now a friend and colleague, and we're now working on a range of human rights issues together, which we're about to do now here in the next few minutes. But post-Cambridge, I, instead of returning to practice in Dublin, as I'd intended to, I worked at Liberty. And I was a policy lawyer at Liberty in those critical years post 9/11 and in the early years of the Human Rights Act. And at a time when many key cases were being brought from the UK to the European Court of Human Rights. So a really critical time and an inspirational and creative time for human rights lawyers. And I was there until summer 2005 when the 7/7 bombings took place, killing 52 people plus the 4 bombers. And again, as in 2001, we saw immediate responses which challenged us as human rights lawyers, including, of course, the terrible killing of Jean-Charles de Menezes. And it was in 2005, just very shortly after the 7/7 bombings, that I transferred to the Bar of England and Wales and have been practicing there since. And in fact, much of my work since that time in the domestic courts has involved acting for bereaved families, including indeed the 7/7 bereaved families and many of the survivors of the 7/7 London bombings, and for a range of families let down by the state, whether it's deaths in police or prison custody, preventable deaths in mental health detention, children who should be in care and are not, and are left in abusive situations, and so on. And I do think inquest law is one of the most rewarding and important aspects of human rights law. And it's like a Cinderella aspect of human rights law. It's often underrated and undervalued. But in my time working on inquests, I've worked with inspirational clients who at the worst time in their lives come to you as a lawyer. And I find whatever the situation is for bereaved families, they usually want answers, they want accountability, most importantly, they want change. They don't want another bereaved family going through what they've gone through. So it's a forensic process acting for families like that. You're also trying to be creative and thinking about how you can use the law for good and amend the law so that other families aren't placed in the same position. Now, Stephanie mentioned earlier that I'm joining from New York today, and looking at the title this morning, it refers to prospects, possibilities, fears and limitations, the conference title. There's a link to the reason I'm here. I just want to make 2 short points about fears and limitations. I'm afraid I'm focusing on the 2 very negative words in the list of 4 there. But I wanted to do that because I'm joining remotely because I'm in New York this week working on 2 things. First, working on cases about journalists and pro-democracy campaigners at risk because of their work in non-rule of law compliant states, as Tatiana's mentioned. And also second, addressing transnational repression. So states targeting journalists, campaigners, human rights defenders, lawyers around the world. So trying to use the long arm of the state to target people, whether they're on the streets of Cambridge or the streets of London, rather than in the actual state, which is doing the oppressing. So first, targeting of journalists, that's become a very significant part of my work over the last number of years. And so I've acted for journalists killed for their work, for their families, like the family of Daphne Caruana Galizia in Malta, for example, and journalists imprisoned for their work, as Tatiana referred to earlier. And often what I find is that those individuals are facing what my client Maria Ressa would call lawfare, so weaponization of the law in an attempt to silence them. And we're seeing increasingly creative ways of the law being used against journalists, human rights defenders, and so on. So instead of just using defamation law or cyber libel laws to try to silence people, increasingly they're now using parts of the law which smear the messenger as well as the message. So, for example, charging people like Mir Shakil or Raymond in Pakistan with fraud, charging Maria Ressa in the Philippines with tax evasion, charging Jimmy Lai in Hong Kong with bogus fraud charges. And that's quite damaging because you do get some people thinking, well, there's no smoke without fire, and it's much harder to get people on board and to understand the pernicious nature of those cases. I'm actually about to meet with Helena and my client, Maria Ressa, Nobel Peace Prize winner from the Philippines. And she is someone who's been targeted for speaking truth to power as a journalist, standing up to Duterte and his murderous regime, and now Bongbong Marcos. And she's coming to join us at a meeting discussing Jimmy Lai, pro-democracy campaigner and media owner, imprisoned in Hong Kong for speaking truth to power. And he's a UK national too. Now, both Maria and Jimmy are brave individuals targeted with lawfare. And they are both individuals targeted with lawfare in countries which proclaim their commitment to international human rights standards, which are parties to the ICCPR, to the UDHR, but which simply in practice don't comply with those standards. That's why the issues Tatiana raised about how we can hold people to account are so important. And I just wanted to tell you one short story about that, which is in December 2021, when Maria was getting the Nobel Peace Prize, she had to provide her speech a number of days in advance because it had to get translated into so many languages. And right at the outset, she said that she was indicative of a wider range of journalists who uphold democracy and democratic standards and human rights and shine a light on abuses of power. And in it, she made reference to the fact that in the Philippines, since Duterte came to power, 21 journalists have been killed. And 24 hours before the ceremony, we learned very sadly that her former colleague, Jess Malabanan, another journalist, had been killed. And we had to say to the Nobel Committee, we have to change the wording. So we know it's outside protocol, but we have to say 22 journalists have been killed, not 21. So it was a really stark reminder of the importance of the prize. But it also leads to the other point that I wanted to raise about transnational repression, because Maria also had to change her speech to reflect the fact that a huge number of lawyers had been killed in the Philippines. And at the time that she gave her speech, it was at least 63 compared to the 22 journalists, because lawyers have also been killed in the Philippines. And in terms of transnational repression, I just wanted to mention that there now is an increasing tendency to target not just journalists or activists, but also lawyers. And what we're seeing increasingly is states using the long arm of the state to try to silence their critics, not just within their own borders, but wherever in the world they may be. So we see that with the shadow police stations, for example, the Chinese shadow police stations. We see it with the disgraceful bounties targeting 8 activists worldwide from China. Or we see it with my clients, BBC News Persian, who are all individuals based in London at New Broadcasting House for the BBC and facing death threats and rape threats simply for doing their job. And I did want to just finally make reference to the fact that tomorrow in Geneva, the Human Rights Council will be looking at the UN Secretary General's reprisals report. And in the reprisals report tomorrow, they will be highlighting the fact that so many individuals have been targeted simply for using UN mechanisms and international human rights standards. And I'm afraid myself and Tatiana have the dubious honor of appearing in that report because we ourselves have been targeted simply for acting for Jimmy Lai and filing appeals with the United Nations. And Tatiana, very bravely, was targeted by China in person a number of months ago when she was with our client Sebastian Lai in Geneva. So I wanted to raise that because many days I think our job is the best job in the world. We work with incredible clients and we get to every day do a job which is hugely important and matters profoundly and utilizes that it's not fair gene that I mentioned earlier. But there are costs to it. And of course, there's a cost in the sense that when you lose a case, it really matters in a way that perhaps another case you could compartmentalize and put it out of your mind. So it really matters. It's the kind of thing which keeps you awake at 2 a.m, makes you worry whether you've done the right thing when something goes wrong professionally. But there is also a personal risk to it. And I did feel I should mention that. But finally, on a slightly happier note, I don't regret for a moment doing this job and choosing this path. It was a meandering route to get here, but it's undoubtedly the right one for me. And I'd encourage any of you in the room who are thinking about it to consider taking a similar path. And it is a hugely rewarding job. There's a quote from Roald Dahl, which I have on my wall in Chambers, which says, "I began to realize how important it was to be an enthusiast in life. He taught me that if you're interested in something, no matter what it is, go at it full speed ahead, embrace it with both arms, hug it, love it, and above all, become passionate about it. Lukewarm is no good. Hot is no good either. White hot and passionate is the only thing to be." And white hot and passionate is what we need to be doing in our jobs. We need to have a job that gets us out of bed in the morning and a job which we feel really makes a difference. And human rights law does that. And the quote is slightly undermined by the fact that those of you who know the storyline to Uncle Oswald will know that the story is rather unsalubrious and about the sexually invigorating properties of the Sudanese blister beetle. It's not the most inspiring of stories, but a very inspiring quote. So I'd encourage all of you in the room to think about human rights law and to think about being white hot and passionate, whatever aspect of human rights law it is that you pursue. Thank you.
Well, I'd like to take this opportunity to thank all of our speakers, and especially Keelan, who's joined us from the United States, but also Tatiana, Eileen, and Ivan, who have given us some insight into the practitioner's world. And thank you so much.